My, my gut feeling is that, again, he was a pragmatic fellow, and I think he would have noticed the rights of the employees, which are also at stake there, and would have looked for a way to respect both, which I think didn't happen. And this also gets snarled up into the question of, what are the rights of corporations, which is an idea he would have had a lot of trouble with. It was not a developed legal concept at the time, so I find it a little unpredictable, but I do think he would have been skeptical of the outcome we have.
So it wouldn't have been an either or for him. He would have looked for some way to strike a balance?
He almost always did. So yes, I think so.
Burt?
My sense, agreeing with David again, my sense is the first thing Madison would say is, what's a corporation? Because the idea of profit-making private corporation didn't really emerge into the American legal sphere until Jacksonian democracy. It wasn't up before Jackson. In order to have a corporation, you had to have an act of a legislature, and only the insiders could do that. And it was a very political thing whether or not you could have a corporation. Jackson campaigned on the fact that this should be available to everybody. And slowly but surely, off-the-rack corporations were possible, culminating in New Jersey's corporate law in 1890 that allowed corporations to own other corporations. So that it took about 60 years for this to evolve, and this was completely foreign to the founders' generation. The founders' generation, if we're serious about originalism, they would know less about corporations than they know about violent video games. I mean, it is completely outside their... Now, having said that, I think Madison would have had a take on this. He would have said, if it's a very small corporation, and query whether Hobby Lobby fits that, because it had 11,000 employees. But if it's a very small corporation, with just a couple of owners and like a family that happens to be incorporated.
Well, that was the case in Conestoga, yeah.
Yeah, that was the second case that was joined with a truly small corporation. I think Madison would have had sympathy to try to find a way to accommodate the deep religious beliefs of the owners. But what he would have said is, can I do it without shifting the cost of giving their religious belief to the employees? Because the one thing Madison refused to allow, and that's what the remonstrance was all about, the one thing that Madison refused to accept was that somebody's deeply felt religious beliefs could force somebody else to pay for them. That's why he was opposing Patrick Henry. That's what Patrick Henry wanted. Now, if what you say, if you view the Affordable Care Act case, if you view Hobby Lobby as a case in which the owners shift the cost of their religious beliefs to the employees through lesser coverage, Madison would have hated it, and Madison would have said it's a violation of the Establishment Clause. You cannot do that. You cannot use law to shift the cost of religious belief. That's why Justice Alito starts the opinion very carefully, and the verdict is out on whether he was correct in terms of fact. He starts that opinion by saying this is a zero-cost case. He uses the word zero cost very carefully to say we can recognize their religious beliefs without costing the employees anything, because the insurance companies have agreed to provide them the same coverage for a slightly diminished premium, because the insurance companies realize that it is cheaper to insure contraception than it is to pay for the birth. And so that they have agreed essentially to bear the cost of the owner's religious beliefs without passing them through to the employees. If that actually works, I think Madison would have cheered Hobby Lobby.